the application of E.ON UK PLC and others, and the Secretary of State for Energy, Security and Net Zero.
May it please your lordships, I appear for E.ON, one of the appellants, leading Harry Gillow, and my learned friend Kieran Beale, King's Counsel, appears for our co-appellant, British Gas. Your lordships may have observed that he acted for Scottish Power below, but is now acting for British Gas. And everything your lordships have in writing is our joint work.
Yes. Before we go any further, I think I should say that, as will be apparent, I imagine you've been told informally, Lady Justice Whipple isn't able to be here in person, but she is sitting remotely, and she's on the screen there in rather reduced form at the moment, but the important thing is that she can hear and be heard. Perhaps I could just ask her to confirm that she can hear and be heard, or can hear, and we can tell her whether she can be heard.
Thank you. I can hear you, and I hope you can hear me.
We can indeed.
We certainly can, my lady. And my learned friends Patrick Halliday and Malcolm Birkling appear for the Secretary of State. Just a matter of bit of housekeeping. Your lordship should have core bundles 1 and 2, and then there are 3 supplementary bundles, 1 which is a fat bundle, 2 which is a thin bundle, and then 3 which is again a fatter bundle.
Yes, we don't have, which would have been useful, but the rules don't provide for it, so I'm not criticising anyone, an authorities bundle.
I was just about to say that there is an agreed authorities bundle, which should have been, my clerks filed with the court yesterday.
Well, it hasn't reached us yet.
I don't know if we have any spare.
Well, look, I think for reasons that may be apparent, I don't think we need trouble with that. I certainly, and I know my lord and my lady, have printed out the things that we particularly needed to read, including most obviously the relevant parts of the TCA.
Yes.
Look, I think I should say this at this stage. It was implicit in my lady's order that she regarded ground 3 as arguable, subject to the delay issue. That's why she asked you to deal with the delay issue in your additional note. And that is also the view of my lord and myself. If I can be frank, we are not so sure about ground 2, but it is again our joint view that if we were going to grant permission on ground 3, this is not one of those cases where it would be helpful to split ground 2 off. Now that means that the central issue is ground 1, delay. And having considered the helpful further note from you and Mr. Beale, we are also, all 3 of us, of the firm provisional view that this is arguable. I say firm provisional view, rather carefully worded, because Mr. Halliday has no absolute right on a permission hearing of this kind to address us or seek to dissuade us. And we have, of course, read the paragraph 19 statement from the Secretary of State and the other paragraph 19 statements from the interested parties. But having said that, we think that since he is here, it would be right that he should have the opportunity, if he wishes, to persuade us that we've missed something. But we would only propose to allow him to make headline points on that, and if we were or might be persuaded, we would give you the opportunity to respond more fully. Mr. Halliday, in a moment, if you wish, and there's no dishonour in saying that you see the writing on the wall, but if you wish to seek to address us, we will give you a short opportunity to do so. I'm talking about, given the listing of the hearing, 10 or 15 minutes max, and probably more like 10 than 15, because if you can't dissuade us that it's unarguable in that time, you won't be by going any That leaves only ground 4. It is likewise the firm provisional view of all 3 of us that that is not arguable, and contrary to our position on ground 2, we do not see any advantage in, as it were, just sweeping it up with any points on which we do give permission. That's a cross point, in case you were worried.
Yes.
Your
Lordship spotted me trying to remember which ground was which.
Now, again, that is no dishonour. We've read carefully the skeleton arguments. We're not positively encouraging you to make submissions on it, but you're here. You or Mr. Beale will have the opportunity after Mr. Halliday to address us on ground 4 if you wish, but on an even more constrained timescale, because it's a very short point.
Yes.
Now, I hope that makes sense to you both. Means that the hearing will be even shorter than the quite tight estimate that was given. But that reflects, frankly, the helpful submissions that we've had and the opportunity to read ahead. Anything else you would like to, as it were, put on the agenda before I ask Mr. Halliday to address us if he wishes, and then you or Mr. Beale to address us on round 4 if either of you wishes?
I'm obviously entirely in your Lordship's hands in that. It is sensible for me to essentially shut up and hear what Mr. Halliday has got to say about
yes.
delay.
What we'll do is we'll hear both. We'll hear round 1 and round 4 first. At that point, we will. Well, I'll say, but let's just deal with this now. We will rise.
Yes.
We won't actually rise because, although that's what we would normally do, because Lady Justice Whipple is only present remotely, the most convenient course for us will be, though inconvenient for you, but can't be helped, to clear the court, and we can have then a private discussion. We will switch off the live stream and then have you back in. But I think anything else is not easy to arrange from our point of view.
The only other housekeeping point is that we do need to apply for the court's permission for a supplementary bundle longer than 350 pages. There is an application.
Was that for the purpose? That was for the purpose of this hearing, was it?
Well, we have indeed. The bundles are sitting there and they're there for this hearing. But they will...
no. Well, if at the end of the day we are going to grant permission, there will then be some question about what directions we give. Frankly, I think I've certainly looked at bits of, though not all of, the supplementary number 3. I think we don't need to worry about permission for this hearing.
Yes.
But the question of what bundles will be appropriate for any final hearing, we can deal with afterwards.
Absolutely. And the government very sensibly told us in correspondence yesterday that it didn't oppose the supplementary bundles being...
Well, all right, someone's had to draft the order. For good order's sake, we will grant permission for this hearing.
Yes.
Because the bundles for the next hearing may
indeed, and the government did in its letter take some objection to some of what was in the supplementary bundles for the longer term. Yes. In which case, my lord, I will sit down and let Mr. Halliday have to say.
My lords, my lady, just as a courtesy, my learned friend omitted to mention that Alistair Richardson also appears for the Secretary of State just by way of presentation.
I apologise.
Yes, and we were told someone will be here, but I'm not sure we were given a name, observing for the...
My lord, yes, I'm here for the Joint Energy Administrators.
Were you introduced? If you were introduced, I didn't hear it.
I'm sure Mr. Hickman needs no introduction to your lordship.
No,
I did not introduce him.
No, right. Yes, Mr. Halliday.
Thank you very much, my lords, my lady. I will take the opportunity to try to persuade the court that permission should be refused on ground 1 because ground 1 does not have real prospects of success.
Yes.
And I have 2 submissions on that point. The first is that Article 373 of the TCA does not remove the jurisdiction under Section 31(6) of the Senior Courts Act to refuse permission for JR on grounds of delay. And I'll develop that if I may. And the second submission is that there's no real prospect that the Divisional Court's exercise of that jurisdiction will be overturned on appeal. refusing permission for delay is a matter of discretion. But the first instance court and an appeal court won't overturn the exercise of that discretion unless there's a misdirection in law, or what essentially amounts to perversity. And my submission is that there is no real prospect of the claimants overcoming that high hurdle. Now, just as an aside, I do have a separate submission on remedy. That is not something I could realistically develop in 10 to 15 minutes. What I propose to do is just mention what it is to the court.
Yes.
And if the court would like to hear further on that, then I'd be very happy to address it on that topic. The submission is, in a nutshell, is that we do not see on our side of the courtroom how there could now be any substantive remedy at the end of these proceedings, even if the appeal were to succeed. As I say, that's not really a submission I can develop in 10 to 15 minutes.
Well, yes, it's not a question of 10 to 15 minutes. We're obviously aware of the point, but we haven't had the developed written submissions on it. We've had some evidence. We've had what Mr. Parrott's Mr. E.ON say about it. Perhaps it's just helpful to say now that our provisional view, having thought about this, is that if we give permission on the primary challenge to the lawfulness of the decisions, there would have to be a separate hearing on the question of the appropriate relief, whether at this level or by remittal to the administrative court. I don't quite see at the moment how it's relevant to the question of the grant of permission, unless you were to say that the appeal was academic.
Well, that is the essence of the submission, but it is not a short one, and it's perhaps not one I can fairly expect the court to determine the absence.
Well, I'm afraid
of
I will, when we rise to the end of your submissions, we will
yes.
discuss that, but my own provisional view is that you're right about that. Even if we gave you an hour or two, we just haven't set up this hearing to deal with this point. So, thank you for mentioning it. We'll have to decide later how we deal with it.
So the first of my two submissions then concerns whether Article 373 of the TCA somehow removes the court's jurisdiction under Section 31(6) of the Senior Courts Act, the jurisdiction to refuse permission on grounds of undue delay. And I say it plainly does not, and I make 5 points about that. The first point, my lords, arises out of the text of Article 372 of the TCA.
Yes, will you just give me a moment while I get my copy of that. Very tiresome. Having said I printed it out, I don't seem to have brought it with me. Did you say there was a spare authorities bundle in court?
My learned friend did, I think.
Well, I'm afraid I was inquiring whether there was one.
Well, we'll manage. It's set out in the judgment somewhere, isn't it?
Yes, mine is.
Oh, somebody's brought it. Thank you. You're right, Steve.
I'm also concerned about her ladyship not having access to.
Well,
I've got it online. As long as I've got the electronic version. So as long as you point me to where we are in the electronic version.
Thank you.
Yes, I also have the electronic version.
And I think I'm looking at tab 10, aren't I? Of the authorities bundle. Is that where I'm meant to be?
Yes, it is. So Article 372, for those who have it, is at page 269 of the authorities bundle, behind tab 10.
Yes.
The courts and tribunals, each party shall ensure, in accordance with its general and constitutional laws and procedures, that its courts or tribunals are competent to review subsidy decisions, impose remedies, etc. And I rely on that phrase, in accordance with its general and constitutional laws and procedures. Section 31(6) is a part of our general and constitutional law and procedures. So far from displacing 31(6), the TCA recognises that UK courts can continue to apply our domestic procedural rules, including section 31(6). The second point concerns Article 373, which is at page 271, for those who have it. Paragraph 2.
Yes. Thank you very much. The sound is, for my lady, proving rather problematic. Could you speak into the microphone?
Thank you very much, my lord. In fact, it wasn't so much hearing counsel, it was hearing you.
Oh, I see.
You could speak into the microphone more.
Right. Is that better?
That sounds a bit better at the moment. I'll signal if there's a problem.
Yes. Thank you. Thank you for that.
Thank you very much.
So this is the crux of my learned friend's arguments. This is the provision on which they centrally rely to say the TCA removes the section 31(6) jurisdiction. Each party shall ensure that, provided that the interested party as defined in Article 369 has challenged a decision to grant a subsidy before a court or tribunal within the specified time period, as defined, recovery may be ordered if a court or tribunal of a party makes a finding of material error of law. Now, it was the use of that word may that was also the crux of the Divisional Court's reasoning on this issue. I won't ask you to turn to it because of time, but I'll quote what it said at paragraph 156 of its judgment. Article 373, paragraph 2, requires only that a remedy of recovery is in principle made available by domestic law. It is expressed in permissive terms, recovery may be ordered. It clearly does not prevent the court refusing such a remedy on discretionary grounds, such as delay. And that reasoning is, in my respectful submission, plainly right. The use of the word may in Article 373, paragraph 2, preserves the scope for domestic judges under our domestic law to refuse relief on discretionary grounds, such as delay. Now, the claimants in their submissions effectively seek to rewrite the word may as must. They invite the court to read paragraph 2 as though it said, if a party brings a challenge within time and the court makes a finding of material error, recovery must be ordered.
Well, do they? Isn't this at least an arguable way of looking at it? Perhaps even a right way of looking at it? That, as you rightly submit, all that happens is that what the effect of 373 is to grant, overall, is to grant a power to make a recovery order, or to put in the language of, I think, the footnote, that remedy of recovery be available.
Yes.
But that is subject to a precondition. The precondition is that the challenge shall have been mounted within the specified time period.
Yes.
And the core specified time period is a month. It's true, because of the peculiarities of the UK. I'm not sure of the drafting history, that we have a rather more elaborate procedure than EU countries. But the point is that if that precondition is satisfied, then the law must provide for recovery to be an available remedy if the challenge succeeds.
But I do.
And if the remedy is not available if you don't challenge within a shorter period, then you've undercut the 1 month period which 373 clearly intends that you should have.
My Lord, I respectfully do disagree with that. There is no inconsistency between, on the one hand, laying down time limit or limitation period for a claim, and then also saying, even if you bring a claim within that time period, your claim can fail on grounds of undue delay. That is entirely conventional. That's the way...
But undue delay means not doing it within the time limit which the primary legislation, which this effectively is for these purposes, the primary legislation specifies you should have.
My Lord, that isn't the way the rules in our domestic JR operate. There's a time limit in CPR 54.5 for starting a claim for judicial review, 3 months and in any event promptly. There is then a separate jurisdiction in section 31.6 of the Senior Courts Act, which says the court can refuse permission or relief on grounds of undue delay. My submission is that there is no inconsistency in those two things living alongside one another. They're additive rules. You can bring your claim within the limitation period, but you can still lose. Your claim can still fail because there was undue delay. And I'd also add that's exactly how the Subsidy Control Act 2022 operates. There's a limitation period for starting claims in that, which is effectively the same as the limitation period in the TCA.
I think we've all agreed that we shouldn't be looking at the 22 Act.
It doesn't apply, but
it doesn't apply.
The reason I'm praetonate at this point is that it illustrates the consistency between both having a limitation period and having a jurisdiction to decide a claim should fail because of undue delay.
In any event, even if you're right technically, shouldn't the court, when it's considering whether there's been undue delay, have regard to the fact that it's looking at a regime which provides for a time limit? It does seem, at least arguably, rather extraordinary that when a party's got an express 1 month limit after obtaining information, to say that when the claim has been brought within a matter of days, it's not been brought promptly, particularly where, as it seems to me here, it's at least arguable that it made absolutely no difference that it was only brought within a matter of, that it wasn't brought any quicker.
My answer to that...
and all this just has to be arguable at this stage.
Well, my answer to that, my Lord, is that the court below did take into account the time limits under the TCA. It received submissions from my learned friends that because of the TCA and because of the time limit in the TCA, it shouldn't refuse permission.
When would the time limit under the TCA have expired?
Well, on one view, it didn't even start.
Exactly.
And I don't seek to rebut that. But that doesn't mean there was no undue delay.
Well,
in fact, in a sense, that illustrates the need for a jurisdiction to refuse a claim on grounds of undue delay. If you have a situation where
why here was there a need to knock out a claim after only 2 weeks after notification of decision? What was the great urgency?
If the claim succeeded, it would have caused, and I used the much quoted phrase that the claimants have used, total chaos. They were seeking the unwinding of an enormous transaction affecting 1.5 million customers.
But we know that in the event, the hearing didn't take place till April. And Mr. Justice Swift said that there was no way it could be dealt with before Christmas.
And that was precisely because of the claimant's delay. The period was actually 3 weeks, my Lord. The decision...
18 days.
Well, no, it's 18 days after 17 days after the hearing before Mr. Justice Zaccaroli. The material decisions were taken at the end of October and then on the 7th of November. And the claimants variously were aware...
Notified on the 10th?
I think 8th, 9th and possibly 10th they
Such a
learnt
power.
of decisions.
Yes.
Yes. So, I mean, in JR terms, the time started running when the decision was taken, but some of the claimants may not have known about the 10th. The judgment below was to the effect that they really had to get their skates on from the 11th of November onwards. And then there was the period of 17 days delay. And the court...
No, it can't be 17 days delay, can it? I mean, what if it had been done within 5 days? Would that have been prompt enough? How quickly?
It goes further.
I'm reluctant to draw a
Mr.
precise
Justice
line.
Saccaroli himself, if I remember correctly, said you really got to do this within, and I think he mentioned 10 days. I forget his exact phrase.
I think that was a submission made by the JEAs. They said a week or at the very most 10 days.
I see it. Well, I may have misremembered.
Correct me.
Yes, I think the point was that was being made by my clients at that point was that there should be an adjournment of no more than 10 days of the Chancery Division proceedings to designate the effective time. That's the time when the transaction was going to effectively occur. And they said, in the course of those submissions on the first occasion for Mr. Justice Saccaroli, well, and of course, if we get to that hearing, and there's still no judicial review proceedings, then all of these complaints about judicial review and extending further will have, they'll have to.
Yes. Okay. Well, that's enough. Thank you. Yes. I'm so
if I
sorry.
could, I would very much like to return to the second submission, which is about whether the Divisional Court erred in deciding that there had been undue delay, and I think your Lordship's question probably pertains to that second point.
It does.
On the hard-edged question of whether Article 373 removes the jurisdiction, I've actually made my third point already, which is lack of inconsistency between having a limitation period. The fourth point is I do pay an aid to some extent the Subsidy Control Act 2022. It doesn't apply here, it's not binding, but I do suggest it's persuasive. If my learned friend's arguments are right, then that would mean that the 2022 Act is contrary to the requirements of the TCA. I accept that's theoretically possible, but it's, I suggest, highly unlikely that the drafters of the 2022 Act got it so wrong. I submit that Section 72.8, which you've been referred to in written submissions of the 2022 Act, which says relief can be refused on grounds of undue delay, illustrates just how ambitious the arguments put by my learned friends are. To put it mildly, the stance that they take on the interpretation of the TCA is not a mainstream interpretation. It's certainly not one adopted by the drafters of the 2022 Act.
Well, we have the point. Is that it on the hard edge?
There's a fifth and final point, which is right. I'm not sure if the court recalls my own friend's reliance on the Uniplex judgment of the Court of Justice of the European Union.
No.
That was a case in which the Court of Justice said that a requirement in our domestic UK law that proceedings to challenge a procurement decision be brought promptly was inconsistent with the EU principle of effectiveness. You have to have, the court said, a hard-edged time limit. Promptly is too uncertain, too discretionary, undermines effectiveness.
Okay, what point are you coming to?
The point I'm coming to is that they're wrong to rely on Uniplex for two reasons. First of all, it's an argument which is wholly reliant on EU law, on Uniplex and the EU concept of the principle of effectiveness. And it's quite clear that the domestic courts are under no obligation to interpret the TCA in accordance with EU law, and we get that from Article 4 of the TCA. It's at tab 10, page 249 of the authorities bundle.
Just one moment. I'm being given a different microphone. Is that better? Yeah, my lady thinks it is better. Sorry about this.
Tab 10, Article 4 of the TCA, paragraph 2, this is under the heading Principles of Interpretation and Definitions. For greater certainty, neither this agreement nor any supplementing agreement establishes an obligation to interpret their provisions in accordance with the domestic law of either party. So on the UK side, the treaty doesn't have to be interpreted in accordance with domestic law of the EU law. By section 31(6), Parliament has legislated that the courts in JR proceedings ought to have a residual discretion to refuse permission on grounds of undue delay, even when a claim has started within the limitation period. With respect, I submit that the courts shouldn't take it upon themselves to usurp that policy choice made by Parliament, especially when they are not obliged to do so.
You are slightly delivering these as fully fledged submissions. These are meant to be headline or bullet points. I get the point.
Thank you. Second point on Uniplex is that it ignores the text of Article 372, which I took the court to at the start of my submissions, which said that UK courts should be permitted to carry on applying on general and constitutional laws and procedures. Well, those are my submissions on the first hard-edged issue.
Yes. Then on the second issue, one aspect of it, my Lord's already explored with you, which is even if there isn't a hard-edged barrier under Article 373, it's still a highly material consideration at the exercise of the discretion. And I think we have your submissions on that.
Yes.
But I'm sure you have some other points.
I do, and the starting point is that Section 31(6) is a discretionary jurisdiction, and that means that overturning a decision under that jurisdiction on appeal is a high test. And as authority for that proposition, we have in the authorities bundle at tab 7, Crown on the application of Thornton Hall Hotel.
And I don't think you need to take us to it, yeah.
It says something that will be very familiar to the court in the context of discretionary decisions. Basically, for it to be overturned on appeal, there has to be either a misdirection of law or something.
It is very familiar.
Amounting to perversity. Now, applying that standard, I say the claimants have not formulated any alleged misdirection in law. Instead, what we have is a series of complaints about factors that should have been given different weight, even though those factors were weighed up by the court below. Factors such as the lateness of the Secretary of State providing them with information, them not knowing the detail of some of the points they subsequently run. But those were all considered by the court below. So it can't be said that the court failed to have any regard to them. So the test is whether, having weighed up all of those factors, Lord Justice Singh and Mr. Justice Foxton reached a decision which was perverse. And that is a very, very difficult hurdle for my learned friends to overcome.
Well, at this stage, they've only got to show that it's arguable that it's perverse.
Yes, absolutely. I'm conscious of the time. I can develop, if it would be helpful, submissions on why the court was entitled to say that the claimants were aware of the essential grounds available to them from very early on.
Well, I think it would probably help us most if you addressed, which I think you began to, but perhaps didn't have the chance to finish, my Lord's point about what I might call prejudice, what difference this delay is a tendentious term, the elapse of this further period really made.
Yes. So on the issue of prejudice, the claimants rely on statements in the Maharaj case that presence or absence of prejudice or detriment is likely to be a quote-unquote key consideration in determining whether there has been undue delay. The first point to make is that the judgment below expressly cited that proposition from Maharaj, paragraph 136 of its judgment, in the final 4 lines. So it certainly can't be said that the court below misdirected itself in law on this point, had it well in mind. And the truth, my lords, my lady, is that really there was no dispute below about whether, to quote the wording of section 31(6), the relief sought would be likely to cause substantial hardship to or substantially prejudice the rights of any person or would be detrimental to good administration. As I mentioned, the claimants themselves had, in the insolvency court proceedings, pointed to the total chaos that would be caused by undoing the transaction after it had completed. That was referred to by the Divisional Court in the section of its judgment on delay, paragraph 139. And then it came on again to mention the prejudice to the JEAs and to Octopus. And it had received detailed submissions and evidence about that prejudice.
That all depends on the relief of unwinding being granted. But it was entirely possible, and is now, it appears, the only relief being sought, that the court might have refused to unwind, but granted a declaration and, if appropriate, the remedy of recovery. That wouldn't have caused the chaos of which complaint was being made, which was obviously what I might call unwinding chaos. What's the position about that?
Well, the claimants make a similar point. They say it was unfair that we weren't given an opportunity to explain how relief could have been tailored to avoid the chaos. But section 31(6) was explicitly in issue in the court below. They knew well there were submissions about whether the court should exercise its discretion under section 31(6), and that included the court having to consider the issue of prejudice and detriment to good administration. They had every opportunity to say to the court, you should not exercise your jurisdiction under section 31(6) because the relief could be X, and X would not cause prejudice or harm to good administration. They chose not to make that kind of submission. Instead, they left it wholly vague what relief they were seeking.
You mean they should have plumped for non-unwinding relief?
Well, it was a matter for them to explain what relief could have avoided the total chaos that they themselves had alluded to, but they didn't do that.
Can you explain to me at what earlier point if the claimants had issued by an earlier point, what do you say would have happened that was different?
There would have been time for these proceedings to be determined before the effective date.
If they'd been issued by when?
The 12th of November, say. And in the context of a very fast-moving and urgent set of circumstances like this, like in the Argyll case, cited in the judgment below, that is the sort of expedition which, in my submission, was appropriate.
So anything issued after the 12th of November would have been undue delay, would it?
I'm not seeking to draw a very precise line between...
But when we're talking about very, very short time periods, surely we do have to consider it, don't we? Because we're talking about enormous claims and potentially enormous professional negligence claims against parties for not issuing in time. We do have, in good administration, we also need to have some idea of certainty. Do we not? I mean, it is having an absolutely arbitrary time limit, which nobody knows what it is, which will knock out claims potentially worth billions of pounds, it seems to me, is parliamentary justice.
Your Lordship's pressing me for an answer, so I will seek to give one. I mean, certainly within 2 or 3 days of the hearing before Mr. Justice Saccaroli on the 11th of November, we say that the JR challenge should have been started.
So you say if it had been issued within that time period, the hearing which eventually took place in April could have taken place in time for the transaction which completed on the 20th of December to have been, and bearing in mind that their lordships took, I think, nearly a month to give judgment in this case.
But that was in a totally different counterfactual set of circumstances where the super urgency had simply fallen away. There was super urgency to get this on before the effective date. Now, by the 6th of December, when we had a directions hearing before Mr. Justice Swift, he said that is now impossible. Once it became impossible to have the proceedings resolved before the effective date, much of the urgency simply fell away, and the parties proceeded on a much slower timetable than would have been appropriate if there had been any prospect of having the claim determined before the effective date. So, I mean, if I plumped for the 12th of November originally, if the claim had been started on the 12th of November instead of 17 days after the first hearing before Mr. Justice Saccaroli, that would have been 5.5 weeks before the effective date of the 20th of December.
The hearing couldn't have been on the 20th of December.
No, I don't say that. I say that's enough time on a super expedited timetable for Secretary of State to put in evidence and detailed grounds for a hearing and for judgment, and even for an expedited appeal. There's precedent for that in the Miller case, for example, where the claim was issued on the day of the announcement that Parliament was being prorogued. There was a hearing within 2 weeks of the claim being issued. These things are possible in appropriate circumstances.
That was a short point of principle, wasn't it, in a sense? Whereas this was an extremely complicated exercise.
This was a complicated exercise. I don't dispute that. I still say that 5 weeks or so would have been enough time on a very expedited timetable. And at the very least, any opportunity of doing that, even if it may not have been possible to realise that opportunity, was lost because of the claimant's delay. And I'm reminded as well that the hearing, even when people took their foot off the pedal, was in February, not in April of 2023.
I mean, let's be clear. I know we all understand it, but what you're talking about is not whether this was because of the delay. It's whether or not that these factors combined together mean that what the claimants did can be categorised as undue delay.
Yes, or whether it was perverse for the court below to categorise that as undue delay.
I focused you on the question of prejudice primarily because that was a point which certainly had concerned us. But if my lord or my lady have other particular points that they wish to be addressed on, they should say so.
I'd just like to ask one question, if I may, which was to do with the date on which the Secretary of State replied to the pre-action protocol response letter on the 23rd of November, so some days after the 12th, which is the postulated date, and that it's a point that's made by the applicants in their recent note. It was only on receipt of the PAC response that they were put in possession of the subsidy control assessment and the accounting officer's assessment, which are two quite important documents, I would have thought, if you're thinking about bringing a JR. What do you say to this sort of the slow disclosure process that we see unfolding during the month of November? How realistic is it to expect somebody to go to JR without those documents?
Well, My lady, this was a point which was expressly considered and addressed by the Divisional Court. It had submissions on that very fact. And its conclusion, having weighed up all of the submissions and the evidence, was that the claimants knew of the essential grounds for their claim by early November 2022. The gravamen of the claimant's claim in these proceedings has always been the same. Octopus was given a very large government subsidy. That wasn't offered to other bidders in the M&A process. Therefore, it's likely that the subsidy was larger than it had to be. If other people knew a subsidy was an offer, they might have put in a better bid. That has always been and still is their central case. And that was something they knew about before they got the SCA, before they got the accounting officer's assessment. And that was why the court said, I say justifiably, that they knew the essential grounds of their claim even before they got those documents.
Thank you very much.
If I may say so, that was extremely succinct and clear, Mr. Halliday. Anything you feel you have been unfairly cut off from saying?
No, Rod.
Very well. In those circumstances, we will hear from whichever of Mr. Peretz and Mr. Beale is going to deal with the question of ground 4. With respect to Mr. Peretz.
Oh, Mr. Ground 4, it was going to be the cost.
Yes, because if you thought you were about to reply to Mr. Halliday, I think what I meant to say earlier, I think I did say, is that we would rise after we'd heard the two of you to decide whether we needed to hear from the other side.
My lords, my lady, I've got 3 points and one short observation. This is ground 4. It's dealt with in our skeleton, paragraph 71. It's dealt with in our note at paragraph 27. In both cases, relatively lightly. The first point is there's a general proposition a claimant who is unsuccessful in judicial review should not face 2 sets of costs. Here we're facing 3. Could I please give you the headline figures claimed by the interested parties? So the JEAs, the administrators, have claimed £2.7 million. Octopus have claimed £2.8 million. The Secretary of State's claim is £1.3 million. Now, obviously, those are only claimed figures, they're not the assessed figures. But on any view, the interested parties are seeking 4 times the amount of money by way of costs that is claimed by the actual defendant, the Secretary of State. My second point is that the general proposition not being liable for 2 sets of costs is obviously subject to exceptional circumstances, but it is, with the greatest respect, not exceptional in a subsidy case for the beneficiary of the subsidy to feel aggrieved if there's a risk of that subsidy being taken away. And so one would ordinarily expect the subsidy beneficiary to pitch up in court to fight its corner in the same way that developers in planning permission cases routinely pitch up and fight their corner in planning cases. And that is not exceptional. And the case that we've cited in our skeleton and in the note deals with inter alia planning cases. My third point is that the high level of costs incurred specifically here, and being on the hook for 3 sets of costs, or 2.5 sets of costs, because I should say the Divisional Court only awarded Octopus 50% of its costs. But being on the hook for 2.5 sets of costs here has a deterrent effect on challenges that would otherwise be brought to the grant of subsidies. And the court has a reference in our skeleton and in the note to the Competition Appeal Tribunal's decision in Durham, where the Competition Tribunal made a cost capping order to prevent high levels of costs acting as a deterrent in that jurisdiction under the SCA 2022. That was then overturned on appeal with the Chancellor, Sir Julian Flo, saying that the overall approach of trying to keep costs down was laudable, but the cap rules didn't provide a sufficiently specific power to enable a cost capping order to be made. And so we submit that if routinely people who are challenging subsidy challenges have to face two sets of costs, one from the defendant public body and two from the person, arguably more than one person, who might be the beneficiary of a subsidy, then that has a real chilling effect on the effectiveness of judicial review of subsidies post-Brexit. My observation is simply that, of course, in the event that your lordships and your ladyship were minded to grant permission to appeal, the question of costs after a substantive appeal would have to be revisited in any event, and that might potentially take some of the sting out of our concern about the cost position, and that, I suppose, might make me more likely to go quietly or gently into that good night. But in the meantime, I do have to deal with this as a freestanding ground of appeal,
of course you do.
Which I hope I've done.
Were the actual figures that you put before us, before the Divisional Court?
No, because they hadn't been calculated at that stage.
But no one had put in.
I don't think anyone put in the schedule.
Well, it was more than a one-day hearing, so they didn't have to.
It's a 4-day hearing, I think, from memory.
Well,
Three
those
days,
figures, are those said to be the joint and several liability of all the claimants?
At the moment, I think there's a cost-sharing order between the three claimants that they will each bear them as to a third. I'll be corrected on that if I'm wrong.
Can you tell us what the claimants' costs were?
I'm afraid I don't have that information to hand, but I can get it if your lordship would like to see it for comparison purposes.
Well, my lord, I'm afraid I don't see probably how at this stage it can affect our question of principle about arguability.
I think my lady had a question for me.
Indeed.
Yes, sorry, Mr. Bill, just to pick up your last point. If we don't grant you permission on ground 4, I think the only way that costs will be amenable to any further review would be if you did get permission on the other grounds and if you succeeded on appeal. But if your appeal was dismissed on the other grounds, then I think the costs below would stand unless you got permission on ground 4.
My lady, that's quite right. What I didn't want was failure at this stage on this particular ground to be used in due course as a reason why we would have to pay the interested parties' costs come what may, regardless of success on any appeal.
Oh,
If
no, I think that's understood. If you succeeded on the appeal, it would all be a very different picture.
There has been some occasionally creative submissions as to what's being conceded and what's not being conceded, but I'm not going to get into the nitty-gritty of that if I can avoid it. Unless I can be of any further assistance, those are our submissions.
No, thank you very much. Well, what we then propose to do is, as trailed, to ask you all, which I appreciate may take a minute or two, to leave court. We will, at this point, switch off the live stream, and we will have a discussion between the three of us. And there's double doors, so no listening at keyholes, please. No listening at keyholes from work.